Hi and welcome to this latest immigration law update video. In this video, I'm going to take a quick look at the new Presidential Practice Statement number 1 of 2021. Now, you may say that sounds a bit boring, but actually it's important because this practice statement brings entry clearance appeals, so appeals with overseas appellants, into the MyHMCTS system. So you now have to lodge entry clearance appeals by MyHMCTS unless it's not reasonably practicable to do so. This practice statement comes into force today, the day I'm recording this video, which is Monday, the 26th of April, 2021. So let's have a quick look through the practice statements. I've shared my screen and we'll have a look at the 3 annexes that are with the practice statements. So it comes into force 26th of April, 2021, replaces practice statement number 2 of 2020. So all appeals must be started using MyHMCTS unless it's not reasonably practicable. I'm going to try and say that word throughout this, to do so. If you're arguing it's not reasonably practicable and paragraph 4 doesn't apply, paragraph 4 is where they're deemed not to be reasonably practicable. You've got to provide your reasons and then the tribunal will decide whether you can proceed without using MyHMCTS. If you're doing a linked appeal, provide the appeal numbers of the other appeals. The deemed cases that are deemed not to be reasonably practicable, appeals under the Immigration Citizens' Rights Appeals EU Exit Regulations 2020, so EU settlement scheme appeals. If the appellant is in detention, or if the appeal is brought by a person without representation by somebody who's qualified within the meaning of Section 84 of the 99 Act. If you're going to argue it's not reasonably practicable to use MyHMCTS, the tribunal will give directions as it thinks fit after that. Now, in terms of directions, the model directions are in the annexes. So where MyHMCTS applies, Annex 1 gives the model directions, so have a read of that. Annex 2 is for cases that are not using MyHMCTS. But we'll see they're going to be largely online and follow a similar pattern in any event. And where unrepresented, Annex 3 applies. If you're represented by a qualified person, you're going to need to provide an appeal skeleton argument. We're getting familiar with those now, which answers the question, why does the appellant say that the decision of the respondent is wrong? It's got to be a concise reasoning dealing with the issues in the respondent's decision letter, and identifying any relevant material. If you haven't got a representative, what you've got to provide is effectively an appellant's explanation of case, which is effectively another name for the appeal skeleton argument, but just not so rigorous in its directions in relation to that. Parties are reminded of their obligations to engage constructively with the tribunal. Obviously, if you started a appeal before the 22nd of June 2020, so MyHMCTS would not apply. Tribunal caseworkers or judges will decide what further directions and case management is given. So let's have a look at Annex 1. This is cases using MyHMCTS. Notice at the start, these directions refer throughout to material being provided. Material is provided only when it is uploaded to the online system, whereupon an email notification will be sent to the parties that the new material has been provided, and time starts to run from when the material is provided. Grounds of appeal are not required. Obviously, you're going to need to tick the boxes in relation to which grounds apply, but you don't need to do sort of fully argued grounds as you may have done in the past. I still get instructions to draft grounds. Really now where you should be instructing somebody to draft something is at the appeal skeleton argument stage. So you can just, grounds are much more simple. It's just filling in the online form. 14 days after respondent's bundle should be provided, must include the refusal decision and any material submitted in support of the application. That's often a problem, that entry clearance officers' bundles don't contain all the material that was submitted in support of the application. Appeal skeleton argument 28 days after the respondent's bundle or 48 days after the notice of appeal, whichever is later. Again, same format as before: summary, schedule issues, brief submissions. Obviously, it's got to be concise, numbered paragraphs, engage with the decision, not include extensive quotations from documents or authorities, but sometimes you are going to need to quote some bits, but so don't be afraid of doing that, but don't do pages and pages of quotes from cases or just say country information. Identify but not quote from any evidence or principle of law that will enable the basis of challenge to be understood. You provide an appellant's bundle, but don't include material that's already in the respondent's bundle. Obviously, if you haven't got a respondent's bundle, I suppose that might be different. But if you've got a respondent's bundle, avoid duplication. 14 days thereafter, there must be a response from the respondent engaging with the ASA in the appellant's bundle, and it mustn't be a pro forma or a standardized response. And then after that, the case will be case managed by the tribunal. Here's the timetable. So it's what I've just gone through, the 14 days, the 28 days or 42 days, then the 14 days. Late material can't be relied upon without leave. Interestingly, for the unrepresented appellants, they refer to permission. Why they've still stuck old language of leave, goodness only knows. But yeah, you've got to get permission if it's late material. If it's within 5 working days of the hearing, a judge will deal with this as a preliminary matter. Party may not rely on material which has not been provided. If it's ruled, if an application is made to admit material and it's ruled inadmissible, the material shall not be uploaded, though the judge must give reasons in his decision or her decision and reasons for the exclusion of that material and identify the material excluded, even though it's not going to be uploaded onto MyHMCTS. Where the material is admitted, the appeal must be stood down and the judge must cause the material to be uploaded as soon as practicable, and then the appeal will proceed, but it won't proceed until the material is uploaded to the system. You can adduce material after the hearing, but only in exceptional circumstances and only as directed by a judge, and that material must be uploaded. Can't upload material after the decision and reasons. Obviously, it doesn't apply to a permission to appeal application, and there's provision there for change of representation. So that is the Annex 1. Let's have a look at Annex 2. If you're not using MyHMCTS, these model directions will apply, but again, the tribunal must have received the notice of appeal and accept that it's not possible for this appeal to proceed using MyHMCTS. Within 5 working days, you've got to provide a direct contact number and dedicated email address to the tribunal and to the other party to enable the tribunal and the parties to communicate online and participate in such remote hearings as are required. Material must be provided by email and made available in such remote hearings as are required. And then here we go, it's pretty standard now, 14 days home office bundle. Here's the provision for the ASA. Here's the provision for the appellant's bundle. Here's the provision for the respondent's response. So here's the timetable, very similar actually, even though MyHMCTS is not being used. Again, here's the provision for late material. There's still the provision that if it's within after 5 working days prior to the hearing, including the day of hearing, the judge must deal with admissibility as a preliminary matter. But obviously we don't have those issues with not being uploaded and then uploading it because you're not using MyHMCTS. At each stage, tribunal caseworker or judge will case manage the hearing. Any party may apply at any time for a variation of these directions, but interestingly, 10.3, a party may apply at any time for a case management appointment. And obviously when the judge or the tribunal caseworker is reviewing the case, they'll consider whether a case management appointment is needed. So that's something to be aware of. You may want to ask for a case management appointment. Interestingly, that provision is not there in the MyHMCTS directions. Then Annex 3, these are the unrepresented appellants. They will take into account the means by which the appellant will communicate with the tribunal, for example, by post, other offline means, or online. And then there's a section A that deals where an appellant, even though they're unrepresented, has appealed online. And then again, direct contact and email numbers. And then the direction on the appellant. And then you've got this explanation of case, which replaces the appeal skeleton argument. And then on receipt of the explanation of case, a tribunal caseworker will consider, before the document is sent to the respondent, whether there should be a case management appointment to enable the appellant to identify the issues in the appeal. So perhaps if it lacks clarity, they'll list it for a CMR, at which then further clarity can be sought. References then to the appellant's bundle, the respondent's bundle then. Late material, obviously there's permission, it says uses plain English at that stage, so similar to the other provisions, and again similar provisions in terms of case management and listing. Then there's a separate section where the appellant appeals offline, and then the tribunal will make directions on a case-by-case basis. So that is the new Presidential Practice Statement number 1 of 2021. And goes through the annexes in terms of the model directions, but be aware now, particularly for those of you who lodge a lot of entry clearance appeals, that you're going to need to start using MyHMCTS to do so. So I hope that video was helpful to you. I will put the links below this video. Thanks.